I'm still puzzling over the chair's distinction between a public report and a report to Congress.
Well,
Just in jest.
there is a theoretical separation, at least.
At least one more door that the information has to pass through, I suppose. I'm intrigued by your testimony, Mr. Fitzgerald, and I appreciate your forthrightness. I wanted to have you talk, if you would, a little bit about the distinction or not between being a special prosecutor and the kind of prosecutions that happen every day in the Department of Justice and in the various U.S. attorneys' offices. And would you mind commenting? We have in the guidance for U.S. attorneys a great deal of material that is born of experience. And is it your sense that in the kind of special situation that you're in with Mr. Libby, that or any other kind of situation like that, that we should use the same kind of guides that the Justice Department has in place?
You mean the Justice Department guidelines?
Yes.
They were, yes, and in fact, I think one common misunderstanding about my role and the team's role in the investigation involving the Plain matter and the prosecution is that people believe that we did not follow the Justice Department guidelines, or it's been said often enough that people start to believe it. That's not the case. As a Department of Justice official, I was bound by those guidelines. Now, what had happened was I was delegated the authority of the Attorney General. So many of the procedures that had to be followed, I was the decision maker.
Right.
But the guidelines were not abrogated for us. And so when you prosecute as a U.S. attorney, you follow the DOJ guidelines. When I was given the authority in this matter, delegated from the Attorney General, I also followed those guidelines. But to answer your first question, I think in an ordinary case, a U.S. attorney has an awful lot of power. We can bring indictments. We can obviously issue most subpoenas without seeking approval from anyone. We can do lots of things, and in many cases, the volume of our cases, we can bring charges that could imprison someone for life without parole without ever going to main justice for approval. It's in certain narrow areas that are important that our abilities are circumscribed, and that comes up in a smaller fraction of the cases. We cannot seek a wiretap without getting the approval of main justice before going to court. We cannot seek immunity, statutory immunity for witnesses, telling them they have to testify but won't be prosecuted. We can't authorize a government appeal. We cannot subpoena an attorney or subpoena a member of the media. There are a number of things we cannot file a racketeering charge. So in those cases, a U.S. attorney has to seek approval from the Department of Justice. Often it's granted, but then sometimes there's a disagreement. But I think sometimes people can forget, and we try not to forget, that the power of a United States attorney is pretty strong, even in an ordinary case.
So even in an ordinary case, you have a great deal of power, and we have guidelines that have been developed over a great long period of time about how to use that power. And so I think it's fair to, I think your conclusion is that if you have a special circumstance where you have a special prosecutor, those guidelines are very important in the process.
I think as I understand it, the regulations, Part 600, which talks about special counsel outside the Department of Justice, requires that those special counsel have the powers of a United States attorney, but should comply to the extent possible with the Department of Justice guidelines. I was not appointed under that. I was inside the department, but I was bound by those guidelines. So whether you're inside or outside, those rules should apply.
Exactly, and we've had a number of cases where U.S. attorneys have pursued very high-profile political kinds of cases, like in your district now, you're pursuing Mr. Tony Roscoe.
And I don't want to...
You don't have to comment on that, but the comment I'd ask you about is the Justice Department, generally speaking, capable of these high-profile kinds of cases, or do we need to have a whole new unit that would have special powers?
I would answer it this way, not talking about a pending matter. In my tenure, my office indicted Governor Ryan as a United States Attorney's office. We indicted his campaign fund while he was a sitting governor. We did not need authority to do the investigation, but we did need authority when we sought a racketeering charge, because that's a racketeering statute. So I think in an ordinary case, even a politically charged case with a high-level official, we have lots of power, but sometimes those powers are circumscribed when we use certain techniques. And
among your guidelines, you do consider the public prominence of a potential person that may be charged with a crime. And as I understand, your guidelines do include, for a political person, that makes it more of a priority for prosecution, does it not?
I don't necessarily agree with that. What I would tell you is it's the nature of the crime. Obviously, in the case of Governor Ryan, which is past history I can discuss, widespread corruption as the governor of Illinois is something we ought to prosecute,
right,
not because he's a famous person, but because what he did corrupted government at a high level, and it sends a strong deterrent message. But that's no different than in a drug enterprise or a gang. We'll go after the most harmful gangs and the ones that are most visible to send a deterrent message. So I think we consider someone's position if they abused it because it makes it more of a crime, but not going after someone simply because they have a high profile.
And when
The
and
time
you
of
have,
the
I
gentleman
recognize,
has
Madam
expired.
Chair, that the time has expired. Can I just follow up with one, I think, short question, which is,
Without
you do have
objection.
guidelines that deal with, help you balance those kind of priorities with the political person, with corruption, with the effective corruption, with the kind of gang. Do you have guidelines that help you sort cases based on those issues?
There are lots of guidelines that we read, but I tell you the most important thing we do is sit in our U.S. Attorney's office and take career prosecutors and vet the case. Can we prove it? Is it against the law? What's the harm? And we hash those out internally before we bring charges, looking to many of the considerations set forth in the guidelines, but our process really is to get a team of people who have experience and bad ideas around.
Thank you, Mr. Fitzgerald. Madam Chair, I yield back.
Thank you. At this time, I would like to recognize Mr. Conyers for 5 minutes.